Good morning. This is Friday, February 4th, 2022. And our first item on the agenda is S-133, an act relating to authorizing the probate division to reopen guardianship proceedings to correct or remedy a manifest injustice. We have on the web page and a letter from is it Diva? Peggy?
What?
The letter that we should be looking at. Eric?
I think it was
You've seen
from,
the
was
letter.
it? Yeah, I saw it. I thought it was Dale, but I could be wrong.
Yeah,
Yes,
yeah, Dale.
Stewart, who recommends that it would be a bad thing to do this. And have you all had a chance to read that memo?
No.
Could you summarize, Eric? Or would that be? Are you the
Well, I
wrong?
don't want to put words in Stuart's mouth, but I think that the summary of it is that they feel that the broad scope and unintended consequences are significant, and that the ability to reopen a judgment that the amendment proposes would allow any judgment to be reopened and would compromise the predictability and finality of guardianship proceedings generally.
Thank you for that.
Yeah, sure.
So we have that. Do you, Judge Kilgore, do you have any comments?
I'm sorry, I hit the wrong key.
Oh, no problem.
There. I certainly concur with what was previously indicated, that finality is, or lack of finality is, an issue in the proposed amendment to S-33 that you are currently considering. And going along with the fact that there's no finality, there's no statement of the relief that may be offered to an aggrieved party. And if the intent is to award damages from a third party, I think such relief is outside the current jurisdiction of the probate court. And to accommodate such relief, the jurisdiction of the probate court would need to be amended and many of the rules changed. So for that reason, I would urge the committee not to do that. In Mr. Searle's testimony, he gave you the example of a habeas corpus situation when a defendant has been wrongfully convicted. Criminal courts don't grant that relief. The civil division has the jurisdiction to hear habeas corpus proceedings. Similarly, if Mr. Searles wanted to pursue damages on behalf of his daughter, he could have filed a complaint in the civil division, which is the appropriate forum. And I guess finally, I'd like to remind you of what Mr. Searles told you at the last hearing. There were 3 appeals to our Supreme Court. The Department of Justice declined to review his case, and the Human Rights Commission also declined to act. Mr. Searles is a vigorous advocate for his daughter, and I applaud him for that. However, Mr. Searles is asking you to provide him with relief that's not necessary. I believe he could have sought relief from our court of general jurisdiction, the civil division. Thank you.
Thank you. Committee, I think it's fairly clear from the testimony, as much as I would like to try to help Mr. Searles and applaud him for all his efforts. I don't think it's a good idea to go forward with S-133 at this time. I really feel bad about it, because I recognize how hard he's worked and how tireless his efforts have been to remedy what he considers a manifest injustice, and which very well may be. But 3 times the Vermont Supreme Court has rejected his efforts. And I'm, so it pains me to say that, but I don't think we have any choice but to not move forward with this. I mean, we could make clear, I think we've made as clear as we possibly can that we've made every effort to try to find a way to give him the justice that he seeks. But I don't think it's really a legislative role. I think Judge Kilgore comments are apt, and that he could seek relief in another venue, if I understand that correctly.
And
Senator White, yeah.
And I think that he was not so much interested in any kind of compensation, but more in an apology. So, but I think you are absolutely right in your analysis there.
Thank you. Senator Baruth.
Can't hear
You're muted, Senator.
I agree as well. I think
Can't hear.
we all feel so much.
Philip, we can't hear you at all. It's just like a bad radio station. Burlington Telecom, is that the?
Well, while he's gone, I'll agree with Senators White and Sears.
I agree also that we shouldn't go forward. I do still think that for his daughter's record, that he might seek sealing of the records from the time when the guardianship of his daughter was involuntary. And I think that he doesn't want to do that, as I understand it from him, but I think that's something that could address that piece. It doesn't address the overall piece that he's seeking, but.
All right, I think it's fairly clear. Hopefully, Senator Baruth can join us shortly. Can you, Peggy, could you check with, well, we're not taking up S.
Can you all hear me now?
Yes.
Oh, perfect. Yeah,
Okay, good.
very normal.
Good. I don't know what's going on with my, I think it might be my computer, because it's giving me messages all the time that my memory is full. So
No,
who knows? My memory does feel full. What can I tell you?
yeah. Well, you can take Prevision.
Okay. I'm
According
happy
to
to
the
take
ads.
anything at this point.
So are you
I-
going to speak?
Oh, yeah. I just wanted to second or third what the chair said. And I think the fact that we all feel so much sympathy for Mr. Searles is good in one way, but in another way, it's an indication that we've really sort of locked in on one case. And I think the risk is that you wind up trying to legislate a result in one case. And he's had such complete treatment by the system and been given every opportunity, I think, to make that case, that I think the wiser thing to do is what the chair suggested. So.
Thank you. Who was the draft person on 180? Eric? That you're as well? You're muted, Eric.
It is.
You're muted, Eric.
Seems to be going around this morning.
I know. We have no idea what you just said.
I should say that. I said, oh no, that's Michelle's bill, but no, it's actually mine. Yes, so I worked on, that's the one about the property thresholds and the joint conduct between defendants for stealing aggregate amounts of property.
Yep.
Yep.
I don't know that there's much we can do with that one either. Although when we need to be careful when we look at criminal class, the classification bill. And I think it's more of prosecutorial discretion, which, you know, is a good thing. But if the prosecutor doesn't want to prosecute, we can't make them. Senator Nitka.
So the question I had, that I don't know if you can answer this, but I'm wondering, could a group of store owners get together and bring a case, go to the court and bring a case themselves, never skip over the state's attorney and bring their own case?
Not a criminal case, no. They could conceivably try and sue for damages to recover the amount of property that was theft and that was stolen in a civil action in the civil division, but no, they could not initiate a criminal prosecution without that's a decision for the state's attorney.
It's totally reserved for the state's attorney, I see.
That's right.
Or the attorney general.
That's true too. Yep, could be the AG.
You might think of going there as a group.
Yeah.
No, it's, yeah.
Or they might try it in Windham County.
Right.
Well, it's definitely a problem.
It's definitely a problem. It was a great idea to do it that way, but I mean, if it's true that LL Bean is leaving Church Street because of that, it seems to me that's really an issue that Burlington should get on and see what they can do, because that would be a terrible thing if that's why.
Yep. And you remember from yesterday when we had the city attorney in from Burlington, there are differences of opinion here, clashes of opinion over policing.
Yeah.
And so, you know, it's a whole huge nest of issues, but I do think it boils down to enforcement after the testimony we heard. So I can see not going forward with that approach. And I struggle to think of any other way you could legislate. It really is about resources and where they choose to make arrests. You know, we had testimony from Kohl's. Kohl's has a huge mall parking lot. And I've always wondered, since this, you heard testimony, and it's true, every single day they have people with shopping carts leaving Kohl's and not paying. And they go out into the parking lot, and all it would take, because they're monitoring the people in the store, all it would take was for them to be in contact with the police outside, and they can say the shopping cart's coming out, the police arrest the person, do that 5 times, and I guarantee you they would stop. But the word is around that even if they're confronted in the store, so for instance, Bonnie Ryder, who testified, she will go up to them and say, would you like help getting that to the register? And they'll say, no, thank you, and then walk out the door. So
Um,
what are you gonna do?
Yeah.
Well, what might make sense is to make sure that store owners, asking them for, making sure that they're aware of their rights to detain somebody.
Mhm.
It appears that they're not aware of that. And if it's such a problem for, say, Kohl's, and I'm sure there's other places as well, they could certainly, it might save them money if they hired private security to detain the person until law enforcement was available. So I think what Eric described as the right to detain could be something as a letter that the committee could send to the Vermont Chamber of Commerce, asking them to make their members aware of their rights.
Mhm. And could we at the same time send it to, for instance, the Chittenden County State's Attorney's Office?
I think we
Indi-
could send it to all law enforcement and all state
Yeah.
attorneys.
And
Indi-
the Attorney General.
Yeah,
Yeah, because I think it's going to get worse before it gets better, particularly in Chittenden County, where you have I think that that's the one thing that we could do, is making people aware of. For me, if I owned a business, it would certainly be cheaper for me to hire somebody in security
Yeah.
to hold the people until police arrive.
yeah. Or even, if you post security at the door and they do what Walmart does,
Yes.
ask
Yep.
you to show a receipt, and then the person leaves the cart and runs out the door. Kohl's isn't so much worried about whether they get the collar. They want the property to stay in the store if it's not.
Yeah.
paid for. So either way, it's on them to hire security, and it's on the police to arrest.
Yep. What do you think, Eric?
Yeah, that sounds, I think I got a handle on that. Yep, you're referring to the shopkeeper's privilege, which I think I described to the committee last week, and
Yep.
that is correct, that stores have a right to detain a person for a reasonable amount of time, to make a reasonable inquiry if they have a belief that they may have taken something. So that's been the law for a long time. So yeah, maybe you're right that I could certainly put together a letter so that kind of remind folks, whether it's the chamber, law enforcement, stores, whoever, that they have that ability.
Yeah, I think I don't think sometimes people aren't aware of their the laws that, but there's no way to make it's all Senator White has spoken many times about her frustration with the Windham County, what they prosecute. I mean, it's like the opposite from Chittenden County. And as long as you have 14 separately elected, here we go again, same as the sheriffs, as long as you have 14 separately elected officials, and there is the effort, I understand the frustration of the state's attorneys. I'm often reminded that not one of them speaks for each of them. They all speak for themselves. And Campbell reminds me of that often when I try to complain to him.
Were you thinking that the letter, Senator Baruth, you were mentioning, or maybe that was not for the letter, but the point about that Walmart has a different approach, for example? I wasn't quite sure if that was.
Oh, that was just a comment. I wouldn't put that in the letter. I was thinking that the letter could start out with what we determined, which is that there is a real problem, a reminder that of the shopkeeper's privilege, and then if it's going to the state's attorney, then and the police that, we think that enforcement is the answer.
Mhm.
And we know they're
Yep.
short-staffed, but just pointing out that there's a gap there.
Yeah, I think and my understanding is if more than one person's involved, they can both be charged.
Yeah.
Yeah,
And-
that's certainly true. I think
And Matt Valerio was talking about, was he talking about conspiracy language? He was saying they could be charged for working together.
well, conspiracy doesn't only applies to a certain listed series of felonies.
Okay.
This isn't one of them. But I think he's right that you could, with multiple actors, aggregate the amount that's stolen, provided that, that's where it got into the whole issue of the Supreme Court case on point that permitted that for larceny, grand larceny, seemed to be saying you can aggravate when the theft takes place, roughly in the same place around the same time. So in that case, for example, it was one person, multiple thefts at one store. And there was another case that permitted it, the more recent one at Home Depot, where it was same store, slightly different time periods, same day, but a little bit supported time. So it just sort of, the more attenuated you get, like, let's say, for example, two people clearly working together, they've made a plan. There's no dispute about the evidence of the common plan, because that's one element you always have to show, some common plan. And if you had evidence of that, but let's say they decided to pick one of the examples we've been talking about, one person goes into Kohl's and the other person walks down to the other end of the mall and goes into Target. And they say, all right, so we're going to do it. We're each going to take $500 or $600 worth of stuff, so it doesn't cross the felony line. That's a little less clear, where they're in two different places. And especially say one person does it at 10 o'clock in the morning and the other person does it after lunch. Two different places, different times. It's just not as clear that they can aggregate.
Yeah.
They could each be charged, of course. And if one person had all the property, another point Matt made is you could, if all the property were in one place, you could charge them with felony possession of stolen property, right? Sort of after the fact, because we're all in one place. The further apart you get in terms of time and location, it becomes less clear that you can aggregate.
I think
But if
all
you're-
that
Yeah.
confuses. I think a one-page letter that describes the shop owner's rights to detain is what's important, and a reminder to the state's attorneys and others that we believe there's a problem that needs to be addressed on the local level.
Yeah, that sounds totally doable for a letter.
And it'd be on behalf of the entire committee, not just one person.
Right.
Now, we've looked at S-180, we find sympathy, but we don't believe that's the answer at this point. The answer is to enforce the law that we currently have on the books.
Yep. Well, I'll certainly send a draft to the committee so that everyone can take a look before we send it anywhere, so you can see what you think.
Well, we're
should be
lucky
changed.
we have an English professor on the
Yes.
That's the first time
On the
anybody's
committee
ever
who can
considered that a lucky
spice
situation.
it up. Yeah. No.
Speaking of stealing, I've got to ask, Eric, where did you get that Ripton post office sign?
Felony.
Right.
Federal
Federal.
offense, yeah.
Yes. Don't tell the US Marshal. Actually, believe it or not, that is legit. That is, my wife's grandmother was the post office mistress in Ripton for 30 years, from 1953 to 1983. And the post office was in her house.
Yeah.
And so people would come to her house to get the mail. And so she had the sign. And when she retired, they let her keep it. And she passed away, it came to our house. So it's
Well-
actually it's a great story, actually.
Yeah.
If that's,
It
if that's
is a
the
great
story,
story.
the statute of limitations is run anyway, so don't worry
Yeah.
about it.
Oh, right, thank you.
But
If someone tries to prosecute, I may be calling you, Senator Benning.
Yeah.
yeah, we've had an interesting one in appropriations, and that's the New Haven train station that they already moved, and they didn't have enough money to pay for the. So, yeah, I suggested we cut it, but they said, well, it's already moved. So
Yeah.
That was actually a great move. That building really needed to be preserved. I was very happy to see that.
yeah, I just was surprised they moved it and didn't have enough money to move it. Well, I guess enough money to. Anyhow, so our next scheduled bill is at 9:45, and that is Ben's bill, and we're going to hear from Steve Howard, and that's the criminal threatening. So why don't we, Peggy, just take a brief break until 9:45 and let Eric go to the post office in Ripton. And
One last little story about the sign. I'll make a plug for her great uncle's book has a book about the history of Ripton. And in the
Really?
book, there's a photograph of her grandmother at the house with that sign behind her.
wow,
Yep.
Where I lived, the post office was also in the people's house. And so you went there, and he also
Yeah.
was the school bus driver.
That's great.
yeah, those small towns. Rupert is similar to Ripton, and when I was first out campaigning, I went to the one-room school in Ripton. In Rupert. And it was amazing that we still had a one-room school,
Yeah.
schoolhouse. And eventually the Department of Education decided that they had to get together. And so the town of Pulteney and Rupert got together and built the Medowee Valley School. But the people of Rupert always felt they lost something in their one-room schoolhouse.
You can come in and Zoom bomb if you want to.
They definitely did. My wife, when she was a student teacher, cut her teeth in a one-room schoolhouse in the town of Linden. And it's a whole different environment. I mean, the kids get much more interaction
See
with
you
the
in the
teacher,
corner.
and they all become responsible for various chores around the room.
Yep.
And it's a